Here's a tricky contracts hypothetical that arises out of the common law. This is a particularly difficult problem, not because the issues presented are so hard, but because the factual context in which the issues arise is so complicated. Take a look at the call of the question. What are Pam's rights, and what types of damages, if any, may she recover? Discuss. Well, we think about damages, and we know that the big distinction is between compensatory damages and punitive damages. We also know that within contracts law, under compensatory damages, we've got both the cover remedy and consequential damages. Other than that, we don't have a big laundry list of damages. So we know that Pam is going to have one or more theories of liability against a defendant. And we also know that she is seeking damages as her principal remedy. We go to the top of the problem, and in paragraph 1, we learn all about the employment statute of a local state, and we also find out about Pam's employment contract. And we see that there's some give and take between Pam and the employer, and the gist of paragraph 1 is to focus our attention on the extent to which the company is free to fire its employees. And I would suggest that the state's employment statute is going to govern the relationship between Pam and her employer at the end of paragraph 1. Despite the fact that the company has made representations to this plaintiff that she will be a permanent employee, I think the bottom line is that she is terminable at the will of the bank under the state's statute, despite the negotiations between the parties. Now, look at paragraph 2. This whole paragraph is about the employee handbook, and it looks to me that this handbook would constitute a writing signed by the party to be charged, the bank, that would bind the parties to the contents of that handbook. Basically, the handbook is saying that any firings would be done only according to a procedure that would be reasonable and fair. In other words, the bank is saying that they're not going to be an arbitrary employer. Are they going to be held to that standard? Well, as it turns out, it isn't that important whether or not this handbook applies based on the conduct of the parties. But analytically, I think it is reasonable to conclude that this employee handbook would be binding on the bank and would hold the bank to a slightly higher standard than the state's employment statute does by itself. The state's employment statute basically says a boss can fire a worker anytime the boss feels like it. And based on the employee handbook, I think we can imply an extra duty of reasonableness and process on the part of the bank. But now go to paragraph 3 and look at what happens here. Don't you agree that the conduct of the bank's president is extreme and outrageous, regardless of the first 2 paragraphs? If this is just a multi-state question about contracts, and they give us paragraph 3 by itself, wouldn't you agree that the bank's president has acted in an extreme and outrageous fashion? Look at what's happened here. Pam, our plaintiff, an employee of a bank, refused a direct order from the president of the bank to join him in a criminal conspiracy to defraud depositors. And it seems to me that regardless of the statutory framework that this dispute arises out of, this is a worker who has been grievously wronged. And she's going to be entitled to basically every remedy in the book. Now look at the last paragraph. Here we learn about facts that go to the cover remedy or the duty to mitigate damages. Pam has searched diligently for an equivalent job, but she can't find one. She's turned down lesser jobs that pay a lot less. Will we require her to take one of those jobs in order to mitigate her damages? Answer, no. Where we have an employee who has been wronged, we're not going to require the employee to take a much lower status job in order to mitigate damages. We're going to let the defendant pay those damages. Then we find at the end of this paragraph the 3 theories of liability that Pam is bringing to court. First, she is alleging a breach of contract. Next, she is alleging wrongful discharge, and then finally, she is alleging a breach of the covenant of good faith and fair dealing. That's a key theory of liability for her because it entitles her to punitive damages. Most wrongful discharge statutes also are essentially tort statutes, and a plaintiff who wins them can obtain a torts remedy of punis. So I look at this situation, and before we even get into considering how to analyze it, I have concluded already that this plaintiff has been grievously harmed by a defendant acting in bad faith, naked bad faith, without the slightest trace of a defense. Now, as a defense lawyer, this is a case I settle. I stay as far away from court as I can on this case, because the only thing that the jury is going to be arguing about is how high a punitive damages award are they going to be allowed to award. So, turn the page and take a look at the outline of issues that I've presented. This is a difficult question, not because the issues are hard, but because we've got to present a thorough, sensible answer to an essay under time constraints. Pam's first theory is a breach of contract theory, and as it turns out, this is her weakest theory of liability, but even so, I award her a recovery even in the breach of contract claim. And here, on an essay, what we've got to do is rehearse the relationship between the parties and explain what it means. First, we consider the contract between Pam and the bank. And to do so, we need to consider the statute from the state, and we need to consider the bargaining that occurred between these parties. Remember, Pam didn't just take the first offer that she was given. She had an exchange with the bank in which she was expressing concern about being fired too quickly. And the bank said, don't worry, we're going to consider you a permanent employee, not a temp. Well, is that good enough to bind the bank to the employment deal? Sure, the deal is fine. But the issue is whether or not Pam's employment deal is terminable at will. I say it is, based on the first paragraph and the exchange and the negotiation between the parties. But now, we have a separate analysis of the next thing that happened in this relationship, the employee handbook. The question presented by this handbook is, does it change the relationship between Pam and her employer at all? I suggest that it does. I suggest that this employee handbook does give to the bank a greater duty than it would have in the absence of the handbook. The employer has assumed a duty to be a more reasonable employer than the state statutes require. And I think that it's reasonable for the bank to make that representation, and it's reasonable for us to hold them to it. We know that employers compete to keep good employees. And one way that an employer can compete is by seeking to make the employees feel more secure on the job. Does that handbook serve that purpose? Sure. Is it a mere illusory promise? Almost certainly not, because the employees will likely rededicate themselves to the employer as a result of this added incentive. So it looks as if the handbook would be binding on the parties. And again, I pause for a moment to acknowledge that a persuasive argument can be made on the other side of that argument, that the handbook is just fluff, that it doesn't change anything, that it's just a feel-good PR move on the part of the employer. And you know, that's not an unreasonable argument ultimately in this case, because it doesn't matter. Pam's claims go beyond a mere breach of contract. However, I would conclude that the handbook is binding on the employer and that the employer has breached Pam's contract. So my answer to the first call of the question with regard to Pam's breach of contract claim is the plaintiff wins, the defendant's on the hook. We'll consider damages below. Next, we consider the wrongful discharge claim. Now, wrongful discharge is about as close as the law of contracts comes to a tortious breach of contract. A wrongful discharge implies that there's something really the matter with the employer firing this employee. And here, I don't think it is possible to imagine facts that serve as a better illustration of wrongful discharge. Why? Because we've got an employee who is living up to the highest standards of her business. We know that banks and bankers have a fiduciary duty that they owe their depositors. And here, Pam has uncovered potentially serious violations of the law. Those laws are on the books to protect the bank's customers. So when Pam went to the boss, to the president of the bank, with these disclosures, the bank president had a duty to help her resolve this problem. But the bank's representative, the bank's president, failed to live up to that obligation. And instead, the president tried to get the employee, the plaintiff, to engage in a criminal conspiracy with the president to continue these illegal practices. And Pam's refusal to cooperate is not insubordination. In fact, it's exactly the opposite of that. It's the president who is acting as a criminal. It is Pam who is defending the bank and the bank's depositors. That's good enough to establish wrongful discharge for sure. Now, has the bank also violated the covenant of good faith and fair dealing? Of course they have. But we need to spend a little bit of time considering what the implied duty, the implied covenant of good faith and fair dealing is. It's implied into every employment contract and every other contract. So the contents of Pam's employment agreement and the contents of the employee handbook really don't have any impact at all as to whether or not the bank breached the covenant of good faith and fair dealing. And so a good answer to this part of the question, if you're writing an essay, requires a careful analysis of the facts. We can't just say the bank was responsible for wrongful discharge, therefore they're also in breach of the covenant of good faith and fair dealing. No, we have to go much deeper into the relationship than that. We have to explain that the covenant of good faith and fair dealing is implied into every contract, and that the conduct of the bank's president would be a violation of this covenant even in the absence of the negotiations between the parties, and even in the absence of the employee handbook. The bank has done wrong, and the bank is going to be liable to this plaintiff in full. Now, we're told that this is a question about damages, so we consider compensatory and punitive damages. We see that Pam has been unable to secure employment in her field. She's going to be entitled to the full price of her employment agreement until such time in the future as she does secure employment. So, the bottom line is the defendants are on the hook for compensatory damages, and the plaintiff's efforts to cover are in good faith, and the fact that she has only been getting job offers for lesser jobs is not something that's going to impact the liability on the defendant. The defendant's liable in full. The plaintiff's efforts to mitigate her damages have been done in good faith. With regard to punitive damages, here again, I just think this is a case the defense has to settle right away. The plaintiff is entitled to punitive damages, and it seems to me that this is a textbook example of a case where a jury's duty would be to award substantial punitive damages. It's hard to imagine a bank acting in worse faith both towards an employee and towards the depositors. And so Pam gets compensatory and punitive damages. Now, one other detail that I would weave into the analysis, going beyond what the question is asking, is this. I think Pam is entitled to specific performance. I think she's entitled to an equitable order forcing the bank to put her back on the job. She is clearly a far more loyal and a far better employee than the bank president. And that wraps up a consideration of a factually difficult, but legally pretty straightforward and simple common law contracts problem.